In what is considered by many people a landmark decision, the Supreme Court last week overturned an important precedent. It's 1984 Chevron doctrine. That doctrine, in the words of Chief Justice Roberts, who wrote the majority opinion that overruled Chevron, that doctrine, I'm quoting the Chief Justice, quote, sometimes required courts to defer to permissible agency interpretations of the statutes those agencies administer, even when a reviewing court reads the statute differently. Close quote. That's from his majority opinion. And now, in other words, like putting it in my words, Chevron deference meant that in some scenarios, the courts had to accept, they had to defer to a federal agency's interpretation of the law, even when the court may have had a different interpretation of the law. So the questions today are, is the overturning of Chevron a good thing? And how good is the reasoning contained in the decision, both from Roberts and the justices in the majority, and from Justice Kagan in her dissent? Welcome to New Ideal Live, the podcast of the Ayn Rand Institute. I'm Onkar Ghate, a senior fellow at ARI, and joining me today to discuss these questions is Adi Dynar, a former student in ARI's education programs, and today an attorney at the Pacific Legal Foundation, who specializes in separation of powers issues and who wrote an amicus brief in this very case. Hello, Adi.
Hi, Onkar. Thanks for having me.
Yeah, and I'm really glad you could join us today. So I thought we'd start off with, so you were on the side, and I think your brief was on the side of urging the Supreme Court to overrule Chevron. I thought you could start off by telling us how I quoted a little bit from Justice Roberts' characterization of what Chevron deference meant, how you think about it. So what is it that has been now overturned or overruled?
So the Chevron doctrine, which came out of the decision in 1984, which was written by Justice Stevens, is a doctrine of judicial abdication, is how I see it. Because what it does is, as you quoted the Chief Justice's opinion from Loper Bright, it requires judges to defer to the interpretation of statutes offered by officials in the executive branch. And it's a shock to the system in the sense of, or it was a shock to the system, because it violated the Constitution's separation of powers and checks and balances on a fundamental level, because courts, if anything, in Chief Justice Roberts' views that have been expressed in some earlier decisions, must act as neutral decision makers without fear or favor granted to any particular party. But the Chevron deference doctrine required courts to put a thumb on the scale in favor of the government and against the individual. So in that sense, the courts really abdicated their role as neutral, objective decision makers when a proper case is presented to them. And obviously, last week, the Supreme Court overruled the Chevron doctrine. And Onkar, I think you start at the right place when you say there are really two questions or two ways of looking at the decision that we got in Loper Bright. One, is it a good conclusion? And are the reasons provided by the justices good enough? And I'm looking forward to sort of talking through that.
Okay, good. Yes, and I definitely want to spend a lot of time on the actual decision and its reasoning, because the tendency when I watch things in the media for Supreme Court cases is to focus on the decision and then speculation about what the consequences will be down the road now for legal cases. But they don't spend a lot of time thinking or arguing when they have experts on. So to sort of analyze, was it actually a good decision? So I want to spend some real time on that. But let me ask you this, and as I said in the intro, you focus on separation of powers issues, and you brought that up in your description here of Chevron. So part of the way I think about why this is a very consequential issue is that it's this kind of issue is very important when you have a mixed economy. So and the way I think about that is as the government gains more and more power and control over people's lives, and both in the decision and if people have read outside sort of commentary on Chevron, that it becomes especially important, this kind of issue, with the passage of the New Deal legislations. And that was really a significant expansion of government control and government power over the lives of people, and like in all areas of life, in business, work, employment law, healthcare, your retirement planning with Social Security and all that kind of stuff, education. And Kagan, in her dissent, makes this point sort of in passing, just the amount of power that the government has. This is one brief quote from her dissent of just listing sort of things that government now does on a day-to-day basis. And it's, quote, the provision of healthcare, the protection of the environment, the safety of consumer products, the efficacy of transportation systems, and so on. And the so on is there's a long, I mean, she doesn't even mention education there, for instance. That's a long list. And when a government has that much control over people's lives, there's a really, really important issue of, is it exercising that power in a legal way, and in a way that is at, I don't know if it can be fully squared with the Constitution. I don't think it can, but at least it has still an element of real rule of law that the government, one can really think, yeah, the government is enforcing the law, not making up the law as it goes along. And that as I read it, the Chevron doctrine, and that what's at issue is the government enforcing a law, or is it making up what the law is? And that the courts are deferring to, okay, if that's what the government now, in this sense, guys, the federal agency says the law is, then that's what the law is. And there's a real, if we don't look at it from the perspective of rule of law, is like, can you as a citizen know what the law is by looking at what the acts and legislation and statutes Congress has passed? Or are you sort of at the mercy of the federal agencies and their interpretation, what they say? And part of I think this comes up especially in Gorsuch's concurrence, that it can change from when you have different people in the agencies, what they say the law is can change. And then as an individual, like, how do you know beforehand if what you're doing is legally prohibited, you're not supposed to do this, or not? Like that I took as like, that's sort of that's what's at stake, or what's at issue fundamentally in terms of thinking about this issue of deference. Is that, would do you see it in a similar kind of way, or would you qualify that in some way?
So that's right, because what Chevron was doing in 1980s was, it was sort of addressing the phenomenon of Congress sort of writing vague laws. You know, they'll write statutes basically saying the federal government officials shall make law that is necessary and appropriate under this new agency that we have created, for example. Congress was sort of putting things in the discussions that led up to the passage of a law, which we call legislative history. So putting, you know, individual legislators' statements in the record, and basically that was being used as evidence of legislative intent, what Congress really meant when Congress put certain words in a statute. And obviously, you know, federal government officials looking at that evidence, or looking at those vague words, would then assert really unfettered discretion in reading those words however they please. And it really sort of gives you a glimpse into the kind of uh, the lack of respect for concept formation, for concepts. And it's really a sort of an interesting glimpse into the philosophical premises of the era, pragmatism or what have you. And that's what was leading a lot of officials to read vague statutes to give themselves more and more power. I mean, think of statutes that say, markets should be honest. What is honesty? What is markets? What are securities? What are stock exchanges? All of those terms were implicit in the concept of, well, markets should be honest, but then Congress was giving up the power to legislate, to make law, to the executive branch when the power does not belong in the executive branch. And that's what was causing all of these vague laws and their interpretations to proliferate at the federal level. So Chevron, at least at the time it was written, was meant to be pretty much a sleeper case. No one really paid much attention to it because it was viewed as the court's way of signaling that we will allow the federal officials to interpret these vague terms because we aren't getting really clear statutes written from Congress. And that was fundamentally flawed as a premise, or it was fundamentally flawed as a principle of constitutionalism, because if anything, the Constitution separates the lawmaking power from the executing power and the judicial power, and the Constitution places the legislating power in the hands of Congress, not in the hands of anybody else. The Constitution says all legislative power, not just any power, not just some power, but all legislative power is vested in Congress. And I mean, the sort of incentives or disincentive structure that developed out of Chevron deference was pretty obvious even at the time of Chevron's when Chevron came out in 1984, which is, it incentivized Congress to write vaguer laws. It incentivized the executive to be effervescent in interpreting those laws to their own ends. And anytime there would be an administration change, the new administration felt pretty much unfettered in its ability to interpret those old statutes, vague statutes, to their own purposes. And that's really from an individual's perspective, every 4 years the law is going to change. We don't know what the law is. We can never know what the law is, because an administrator has both the power to enforce the law and the power to make the law. And that was the system of government that really Chevron incentivized and put in place. So Loper Bright, I think, needs to be viewed in light of what Chevron was meant to support, and what Chevron actually accomplished as a result.
So let me ask you this as a kind of summary, and if you would add anything. So in terms of what impact and consequences Chevron had, so part of what you were saying is it incentivized Congress to write vague laws, presumably because it's easier to pass vague law, like to get agreement when people don't even know quite what you're agreeing to, and then punt it to the executive branch. You figure out the details, and in that sense, the executive branch is not enforcing the law anymore; it's making the law, and and in that sense, it's taking power away from Congress. So it incentivized Congress to write vague laws. That in turn incentivized federal agencies to claim more and more power, because if it was vague, it's a kind of reasonable, permissible interpretation, even if not the best interpretation of the law. But as long as it was permissible, the courts were supposed to defer to that. So it incentivized them to claim a lot of power. And you didn't say this, and this is part of what I want to ask if you would agree with this. The consequence for individuals is you would much less you would be much less likely to challenge federal agencies in court, thinking you're going way beyond what the law says, because the courts, if they're so deferential to federal agencies, you're likely to lose that case. And so you don't even bring it in the first place. It's not that you lose it; you don't even bring the case in the first place, and that's a kind of unseen consequence of it, that one might think, well, but you still have cases, but all kinds of cases that maybe should have been brought weren't brought because the everybody knew that the court would be deferential to whatever the federal agency, however they interpreted the statute. So would you say, is that a third? And I'm interested, maybe to before now we'll turn to the reasoning in the decision. But what are one or two examples that you hold sort of as like these are paradigm examples of what Chevron meant in actual practice? You brought up one about markets must be honest, but do you have a few of those of how you think like that? If you want to get it more concrete, this is what Chevron meant in practice.
Sure. So I think you're right about sort of the third consequence that you described. Many cases were simply not brought because you knew there was this doctrine of deference where where Chevron essentially had said, whenever we have a disputed interpretation, an individual is looking at the statute and trying to organize their affairs to the best of their ability. But there's always going to be a federal bureaucrat that is going to interpret a statute in a different way. And there is no way for the individual to convince the court as to why it makes sense for the individual's interpretation to control. That's the sort of like bias or systematic bias that the majority opinion and the concurring opinion from Gorsuch talks about in Loper Bright. So that definitely has been the word on the street, so to speak, for the past 40 years is if you're going to bring a case, be prepared to lose because there's this bias in favor of the government interpretation, thanks to Chevron. So in terms of real world consequences, I mean, we see a lot of vague or vaguely written statutes relating to environmental protection. You see, the Clean Air Act or the Clean Water Act. It's sort of the basic idea is the environment needs to be protected, and the Environmental Protection Agency or the Army Corps of Engineers can make all manner of necessary decisions to protect the environment. And consider what sort of impact that vague law has. I mean, you have farmers or a sawmill or a woodworking workshop, or simply a family that is trying to build a home on a plot of land that is close to a river. All of those individual decisions are now going to be overseen and regulated by some federal official. Is the individual's decision harmful to the environment? Well, who is to say? It's the federal official that has the final say in that, and the courts, this idea of expertise or efficiency, are going to defer to the federal officials' interpretation no matter what, because it is a permissible construction of the statute, and the statute gives the federal officials a tool, go and protect the environment. And obviously the federal official is going to use that tool in any way that the official deems reasonable, and that has been the real world impact. It has there have been many industries that have sort of subsumed or assumed that's the cost of doing business, is to appease the federal regulator as opposed to sort of looking at law in an objective way. And some industries have built that into their business model. That's just the cost. You have to convince a federal official that you should be allowed, you should be permitted to build a house here, or you should be permitted to continue your sawmills activities or your farming activities. So it turned what we knew as natural rights and rights of individuals into permission slips given by government officials to you before you could actually exercise your rights, and that was a significant departure from what we know American Revolution stood for. Um, so those are some of the real world consequences, and as you probably can discern, they were massive.
Yeah. And one way of thinking about it, or one way it will be often put, is in terms of thinking about rule of law, you're going from rule of law to rule of men. The more and more it's just, I have to win the approval or favor of some particular bureaucrat who happens to be in office now and overseeing this part of the country for, say, environmental laws. Then it's much more, this is a rule of men, not rule of actual laws. It's sort of the semblance of the rule of law, but it's not actually that in practice. And that's one of the ways of holding that it's a major issue for what the structure and division of powers is in our constitutional republic. Okay, so let's turn to this decision. Chief Justice Roberts writes the majority opinion. There's a concurrence, brief concurrence from Thomas, a lengthier one from Gorsuch, and then Kagan writes the dissent in which Sotomayor and Jackson join. If we start with the majority opinion, and I'm interested just so your overall what you think is good in it, what you think is not. But here's one particular question as well. Um, how much do you think the Chief Justice's opinion is focused on the issue of separation of powers? Because Thomas's concurrence is, the way I read it, but I might be reading it wrong, is it's sort of, I wish the majority opinion had also talked about separation of powers and overturned it on these grounds, because it's another and the most fundamental way in which Chevron is unconstitutional. The Chevron deference is unconstitutional. So is that a right reading of it? That there seems to be, like, in some ways, that Roberts is sort of skirting around the issue of separation of powers, but it's never mentioned explicitly. It's only mentioned explicitly by Thomas in his concurrence. So so the basic question of how do you think of the actual reasoning in it, and since you specialize in issues of separation of powers, particularly from that aspect, how do you see it?
So the Chief Justice's opinion really is a mixed bag. I mean, it reaches the right conclusion, but the reasons for reaching that conclusion aren't really fleshed out in the opinion. And there are good reasons why the court needed to do that, to garner a majority. There's some understanding that you have to address the arguments in Chevron and sort of debunk those arguments, or sort of show why what was said in Chevron is wrong, to then say that Chevron should be overruled and go no farther than that. I mean, that really seems to be the sentiment of the majority opinion. Is, yeah, I as the majority author, I need to show why Chevron was wrongly decided, and here are the reasons why Chevron was wrongly decided, and sort of leave it at that. But really, I mean, the Justice Thomas, I think, talks about this, and Gorsuch. I mean, it's sort of implicit in some of the premises in the way that Justice Gorsuch wrote a concurring opinion. The court definitely is aware of the separation of powers principles, the structural constitutional principles that are meant to protect individual rights against government encroachment. So the majority definitely is aware of Chief Justice Chief Justice Roberts is aware of that, but it doesn't come out in the majority opinion. And when you read the opinion, it sort of hangs everything on this statute called the Administrative Procedure Act, which says that courts shall interpret all questions of law, both statutory and constitutional. So I think what's happening in the majority opinion is the Chief Justice is gravitating toward a statutory reason as the bare minimum reason why the Chevron doctrine of deference was wrong, and not taking that further step to explain why, as a constitutional matter, um, the Chevron deference doctrine was wrong. And that is maybe a gap in the majority's opinion. And Justice Thomas, on the other hand, he has in some previous cases, like the Baldwin versus United States case, which he cites pretty extensively in his concurrence, he really went through the constitutional separation of powers reasons as to why it is wrong for courts to defer or be biased in favor of the federal official and biased against the individual. And that, so he talks about how that really uh, tips the scales of justice in favor of the government and against the individual, when the Constitution written to protect the individual from government encroachment of the individual's rights. And it would have been, uh, if the Chief Justice had wanted to provide the constitutional reasons, I think he could have done that. I can't imagine Justice Thomas or Justice Gorsuch not joining those opinions, but I think that would have given more ammunition to the dissent written by Justice Kagan to then punch holes into the underlying fundamental principles that are derived from the Constitution and our structure of government. And historically, that has been interesting because if you go back to, let's say, Robert Bork's confirmation hearings, the idea that the Constitution is pretty much an ink blot is a premise that is prevalent in the thinking of many justices on the Supreme Court. It's, again, obviously not a partisan issue, or it's not about which precedent appointed which justice, but that understanding that the Constitution doesn't really address some of these fundamental principles, or doesn't, or fails to give the reasons for the existence of the kind of structure that we have, is pretty prevalent. And I think there is some hesitation from justices, all nine justices, really, to peg the reason for overruling Chevron on the Constitution alone. So I think that's what you see when the Chief Justice says, well, we are pegging the reason as this statute that Congress enacted, as opposed to having sort of like a full-throated defense of their current position in Loper Bright based on the Constitution.
So let me ask a follow-up on that. So you brought up, because it features heavily in both the Roberts's opinion and then Kagan's dissent, the APA, so the Administrative Procedure Act, which was a 1946 act, I think, passed by Congress. And so Roberts's reading of that is that Congress is charging or at least this is how I understand what he's arguing, that in that act, Congress is charging the court as you have and sort of must retain final decision making about what the law is. So you can't defer to a federal agency and say, okay, their interpretation of what the law is, that's what we're going to go with. You can only do that if you agree with the federal agency's interpretation. But if you don't agree with it, then you can't defer. And that's what this act charges charges the court with. And that he makes a point of saying in the Chevron, so the 1984 case, they never even deal with the this APA act and say why this deference or this kind of test is compatible with that, and that's a major flaw in the Chevron decision, that of why it was wrong from the start, because it never tries to reconcile itself with the APA Act. But a way of reading that kind of argument, and it might be an uncharitable reading, but so this is the question of that if Congress had said, or if they pass a new statute that says, no, we want the federal agencies, and I want to talk a little bit about this, but it's particularly supposedly in cases that where the statute is ambiguous, or sometimes it will put as silent, so it doesn't seem to speak to that particular issue, that then the agency can decide. And if Congress passed something like that, then there's a question of, then would the courts have to defer? And that seems like a separation of powers issue, that, like, does Congress even have the power to issue a statute like that saying, okay, on this issue, the courts don't get to decide what the law is, the federal agency get. So there's that kind of, you could read, as I say, it may be an uncharitable reading, and I have some reasons why it might be uncharitable, but that's a way of saying, like, okay, if it just so happens Congress passed the APA and it's telling courts to make the final decision on what the law is. But if they had passed something different, then the courts would lose some of their power. And that seems like a separation of powers issue.
That's right, and I think that's the sort of flaw in the premises of the majority opinion, because yeah, it does allow, or it does contemplate the possibility that Congress could come in and say exactly what Chevron said, and then the courts will simply have to apply that. But what that argument, I guess, fails to contemplate, or fails to sort of like see two steps ahead, is what does it mean for an Article 3 judge, a federal judge, to judge, right? What is the judicial power? And the majority opinion does not really get into that, except to say that, well, the principle that a court should say what the law is comes from Marbury versus Madison, which is the famous case from 1803, where which has been cited really hundreds of times for the proposition that courts have the core judicial power that not even Congress can take away from the courts. And so the majority opinion does cite Marbury versus Madison, and talks about the history of how that Marbury principle and applied consistently throughout the 200 plus year history of the United States, except for the Chevron experiment. So there's definitely some flavor of or some understanding as to the role or the core functions of the judiciary, but again, there isn't a full-throated argument in support of that. It's sort of almost hidden in the way that the majority talks about Marbury.
Yeah, that's in my reading of it. You put it as is hidden. That's how I experienced it in reading the majority opinion. Um, so let me ask this, because it's an issue that is at issue, so at play in the majority opinion and the dissent, which is the issue of thinking about statutory interpretation. So interpretation of what the law means. What is the law that Congress has actually passed and now needs to be enforced? That issues of ambiguity or silence in the statute, how should a court proceed? And the the if I understand right, the Chevron doctrine and the deference is only in the case where the law is not clear or crystal clear. If the law is crystal clear, then it just means what it means, and the court and the agency, like the court should apply that to the agency. If the agency is trying to go around that, it can't do that. But if the statute or the law that Congress has passed is ambiguous in various ways, and you were saying earlier they were incentivized to write it ambiguously. If it's ambiguous or just silent on some issue, in Robert's opinion, it's still the court's responsibility to come to the single best interpretation of what this statute means, with its ambiguities or silence. And the in Kagan's dissent, it's but if I put it something like this, if it's ambiguous or silence, there's not a single best interpretation. There's interpretations plural, and that's where the deference occurs. That it's if you can interpret this in 5 different ways, you allow the agency to do that, and there just isn't a single best interpretation. How do you think of that issue, and in particular, in I mean, you have much more familiarity with the actual legal cases where this is at play and in issue.
Yes, I mean, that was, I think, the most interesting debate that occurred between the competing opinions that we saw in Loper Bright. So I think there are three arguments at play. One is, there are certain presumptions in the law, and that's how, language and cognition functions. And that's where the majority and Gorsuch are coming from. Is, we obviously have certain presumptions. One of the presumptions is, for example, that if there is ambiguity, then it is resolved in favor of the individual and against the government, because that is why we have governments established among men. And so then Kagan says, well, you're trying to fight one presumption with another presumption. So she says, for example, okay, there's the rule of lenity. So if let's say there is a statute that says if somebody willfully or recklessly drives and causes injury to someone, then that's a crime punishable by 2 years in jail. And let's say the prosecutor, which is the executive, is trying to prosecute somebody, and all they are able to prove is that somebody drove negligently on the streets. The statute just says willfully or recklessly. The statute is, ambiguous or silent as to whether negligent conduct rises to the level of the crime that is defined. And in those circumstances, the presumption or the rule of lenity, the way it functions is that gives the benefit of the doubt to the individual. So if all that the government is able to prove is negligence and not recklessness, which is a higher sort of mental state or a more sort of focused mental state than merely negligent mental state, then the government doesn't win. The individual goes free. There may be other statutes, for example, there may be civil that are applicable in the situation, but it's not a crime to negligently drive and injure somebody, because that's what the statute says. So there's this interesting give and take or back and forth between, Chevron itself was a presumption. The presumption was if there is an ambiguous or silent statute, then the government wins. Whereas, Gorsuch comes in and says, well, actually, historically speaking, the presumption was the opposite, is when there is an ambiguous or silent statute, then the individual wins, the government loses. And, we are simply returning back to applying that historically grounded presumption as opposed to applying this new presumption that Chevron created. So then Justice Kagan comes and says, well, okay, yeah, I understand you're just fighting one presumption by another presumption. And that's her way of saying, well, you can't really fight bias with bias, right? Chevron, if anything, was a doctrine that required judges to be biased in favor of the government. And now you're saying, okay, now there is something in the Constitution, you won't tell us what, that requires us to be biased in favor of the individual. So yeah, that's just bias versus bias. That isn't persuasive to the dissenters. What about expertise, and what about efficiency? So Justice Kagan goes on to say that, well, these agency officials, federal officials, are the experts. They know what honest markets are. They know what needs to be protected when they have the congressional mandate to protect the environment. They know what types of immigrants are repeat offenders, or there is some intent to not comply with the nation's immigration law. So they are the experts. Why don't you allow those experts to decide these issues? And then the court's job is easier under Kagan's worldview, because the courts simply have to see, okay, well, I may have reached a different decision, a different conclusion, but the federal official's decision is reasonable. It's permissible, so I'm going to allow the decision to stand. Um, and the problem with that is, that doesn't recognize that the federal official is not the only expert in the field. And the chief justice in his majority talks about, well, expertise really depends on what field you're looking at, or what's the context of the expertise. I mean, it is not the case that courts do not have access to expertise, right? I mean, courts have the sort of basic idea of a fair trial in a fair tribunal means that courts have access to expertise. The government um, can bring experts to testify. The individuals can bring the experts to testify. So it is not the case that courts do not have access to expertise. And it is not the case that only federal officials have a monopoly on expertise. Because if anything, the core of judicial power requires courts to be experts in interpreting the law, because that expertise comes from a deliberative process, an adversarial process that requires courts to look at concepts for what they are and see, what reference are really encompassed within particular concepts or particular words that Congress has used in enacting. So there's this interesting mixture of sort of presumption versus presumption, and expertise versus expertise, or categories of expertise and efficiency, that is really is a good discussion to have, and I think we'll continue to see that. But I think it ultimately is missing the reasons why the Constitution has deliberately separated the powers, and what it means to judge, what it means to legislate, and what it means to execute the law. And that's something that we did not see in the opinions.
Yeah, I want to come back to that point, and ask some follow up about some of the presumptions. But first, on the issue of expertise that you brought up, my reading of it, but I'm curious if you think this is uncharitable, is it's so implausible to say that courts don't have expertise that it's a kind of smokescreen. Um, because, but maybe there's a difference between when you're looking at this kind of statutory law and federal agencies. But in the civil courts, I mean, I know I have a bunch of engineers in my family. When these kinds of cases go to the court, they're extremely complex. There's all kinds of scientific and engineering issues at dispute in the contract dispute. Like if you fulfilled your end of your contract and someone else, that if the court really didn't have and couldn't get this kind of expertise, one would think like all these decisions are, they sort of just, they're making them up, and it's almost like they're guessing because they don't have expertise. So if you really thought that, it would be like our whole system wouldn't work if courts don't have expertise. So I found it like very implausible as an argument that you have to defer because federal agencies have expertise and courts can't. But is there a more charitable reading of that?
I don't think there is. I mean, I would definitely struggle to think there is a more charitable reading of that, because, so I mean, there's factual expertise and legal expertise. There's, we know from the way that our system of government functions that, there is going to be factual disputes, like a breach of contract, where some engineering firm is trying to prove that, well, actually we satisfied the terms of the contract, and the other side is saying, well, actually no, I mean, here are the reasons why we feel that there is a breach, because we asked for tax, you gave us screws. I mean, that doesn't help us. So I mean, some factual issues are going to be easier to resolve than others. but I think the clue to understanding the Chief Justice's opinion is because it talks about, well, there's the agencies can develop those facts, and we have tools both in the judiciary, and there are tools that the federal officials can use to develop that factual basis for their respective positions. So I mean, consider what tools courts have. Courts, we have depositions, testimony in court, we have jury trials, we have rules of evidence and procedure that are designed to be fair and put both parties on an equal footing. And then compare that to the tools that the federal official has. The federal official, the tool of investigation, they can investigate whether somebody actually committed a fraud on the market, or whatever facts, the underlying facts or elements that the federal government needs to prove against the individual. They have investigatory powers. They have the power to subpoena documents or subpoena a person to testify, and those tools are designed to understand or give access to expertise to really everybody, not just the federal government, to the courts and to the individuals involved in these cases. But what this argument from expertise that Justice Kagan brings does is it sort of it's like a bait and switch. She talks about sort of legal expertise and says, well, if you want to find out what honest markets mean, you have to ask people who have been regulating the securities industry for 20 years, because they know it inside out. They are the experts. If you want to ask about, she gives the example of some FDA regulation about protein sequences. It's like, oh, courts don't understand this medical terminology. You have to rely on the experts, and her worldview of experts is pretty narrow, in the sense that, well, the only experts she would recognize is the federal officials who have been tasked with regulating. But I mean, that isn't obviously the end of the sphere of expertise, because you're going to have experts in the industry, right? The regulated party, for example, a pharmaceutical company, is going to have scientific experts who are able to demonstrate factually why this regulation doesn't apply to the particular protein sequence that this lab has developed, for example. So the expertise discussion is sort of intended to obfuscate rather than clarify. It is intended to be a package deal, really sort of trying to sort through concepts, and that's I think a flaw in the dissent's reasoning.
Okay, yeah, that's certainly how it came across to me. So on the going back now, and I think to the more fundamental issue of presumptions, that's part, as you were saying, part of what's in dispute about, and what between the majority and the dissent, and what's proper presumption. And I think you said at the end, which I agree with, that you can't think of what presumptions and proper presumptions would be absent thinking about the wider structure of the government, and why there's a division into an executive, a legislative, a judicial branch, um, and thinking about checks and balances, and why that was thought important, and how that in practice would be carried out. And I, in my reading of the dissent, and so Kagan's dissent, it comes out pretty clearly the way that she thinks about it, which is that so if you have the presumption that you defer to the federal agencies, there's a kind of, what would justify that is, we know government has all kinds of powers, and yeah, okay, we have to get clear on exactly what those powers are in this instance. But we know it has a lot and a lot of power, and so let it decide sort of the contours of that. Versus if you think, no, the government doesn't have any power except what's actually and explicitly delegated to it. then it becomes, if you can't find that it's really been delegated, it hasn't been, like, the presumption is then it hasn't been delegated, versus the presumption is no, the government has this power unless we can find it explicitly, it's sort of prohibited to the government to have this power. And so when they defer to the federal agencies to something that's permissible, it, like, it's in, I think of it as in that wider context. And she brings up, I thought one of the things in the dissent that's revealing, just the formulation in the way that she formed it's in thinking, and she calls it, this is not really deciding what the law is, it's policy making. And she describes it like that. The task is, so this is about sort of the power of a federal agency. Quote, the task is less one of construing a text than of balancing competing goals and values, close quote. And that's the policy making is, well, I've got to balance competing goals and values, and one administration might do it in a certain way and the next administration does it in a different way. This is why it can change from administration to administration, and the courts are supposed to say, okay, that's permissible, we're not going to do anything about that, even though the agency's own interpretation of the law is changing from administration to administration, because it's just a variation on how they're balancing this what competing goals and values. But there's a real question, is like, is that law anymore? Like, and so what does policy making mean, and how is that an executive function? Like, why is that not a legislative function to make policy? But she's trying to put it in the executive branch, that like it's and that seems like that's like a core issue in terms of separation of powers and how to think of these various branches. And is that how you read, like, what's part of what's going on?
Yes, and I think, I mean, what Justice Kagan is addressing is the consequences of the Loper-Bright rule. So she's trying to sort of project into the future and sort of trying to see, okay, have Loper-Bright, which says the courts are going to provide the best interpretation of the statute. What does that world look like? And from the majority's view, that world looks as follows. I mean, in under the Loper-Bright rule, a judge looks at a statute, and the courts are going to be looking at statutes that are 100 years old, statutes that are 20 years old, statutes that are very recently enacted. All types of statutes where, if they encounter an ambiguity or silence, all that the courts need to do is say that, well, okay, really this statute is hopelessly ambiguous. We cannot figure out what this statute means. There is no best interpretation of this statute. And what that permits, or what that incentivizes courts to do, is to then look at the underlying sort of issue, which is, okay, Congress wanted to make markets honest. But what power is Congress really exercising there? Is it the commerce power? Is it constitutional under the Commerce Clause of the Constitution, for Congress to say that any financial activity in some rural part of the country is going to affect interstate commerce, and therefore, based on that authority to regulate interstate commerce, we are going to require markets to be honest, and then give policymaking authority to the executive branch to decide actually what that honest market looks like. So I think it will, the worldview from the majority's perspective is that will incentivize courts to have an honest discussion of the underlying issues. What power is Congress really exercising when it's speaking through vague and ambiguous or silent statutes? Whereas from the worldview under the dissent's perspective is, yeah, but that's giving too much policymaking power, too much control to the judges to dictate who gets to decide the policies for the nation. And it is very practical, or it's very efficient to allow federal officials to make those policy choices because, the premise being Congress is dysfunctional. It doesn't do anything nowadays. Legislators are interested in sound bites on social media as opposed to actually doing the work of drafting statutes, getting majority support, getting them enacted through the congressional procedures, presenting it to the president. The president might veto the statute and then it comes back to Congress for amendment. So that whole process of making law is very, very inefficient, according to the dissent, and therefore it is appropriate for Congress to give its lawmaking functions to somebody who can be extremely efficient. And that somebody just happens to be the president and the executive branch. And that is the system that Chevron incentivized, that Chevron put in place. And we like that system because, it's cozy and nice. It's sort of like psychologically understandable. But what the dissent fails to understand is that, the majority's sort of implicit premise is no, because, you still have to deal with words that individuals are reading, that the common man on the street is reading a statute and trying to ascertain what conduct is legal, what conduct is illegal, and we have to interpret the statutes and, put that common man on an equal footing in a fair trial, in a fair tribunal against the government. And it will lead the courts to have that honest discussion about congressional powers down the road, and that consequence, I think, is scary for the dissent because there's at least a few justices and a few judges on the lower courts that do not want to tackle the extent of the powers of Congress. Because we have seen what happened to the Commerce Clause. We have seen what happened to the Necessary and Proper Clause in the Constitution. We see taxing, bankruptcy, all coin money, all sorts of powers described in the Constitution that are given to Congress, and courts have largely gotten themselves out of the trying to interpret those sections of the Constitution. But Loper Bright would flip that and require courts to go there, where they have been hesitant so far.
Okay, that'll be the last thing I want to ask you about, sort of what you think of, and I know it's part guessing what are going to be now the consequences of this, but just before that, the one of the last issues you brought up, my reading of this dissent, and the question is this also your reading? Is Kagan never addresses this kind of rule of law issue of, can an ordinary citizen going about their business, trying to build a house, start a farm, can they look at the statutes, and even the statutes and some of the decisions that have, when things have gone to court, and say, okay, I know what I'm doing is not legally prohibited, I'm in the clear and I'm going to do it. So that kind of rule of law that in advance of your actions, is this something that is on the right side of the law or on the wrong side of the law, or you have to wait for the latest administration and its bureaucrats in the federal agencies to tell you, oh no, our interpretation of it is you can't do this. And that really destroys rule of law. And my reading of the dissent is it never even tries to address this issue. Is that your reading?
Yes, and I think both the majority and the dissent, and even the concurrences to a large extent, are skirting around that issue because it is an issue on which, I think it's a lot of justices hold mixed premises on, and we see that play out in other decisions that that are decided a certain way, for maybe the right conclusion for the wrong reasons, or right conclusion for the right reason, or wrong conclusion for the right reasons, or wrong conclusion for the wrong reasons. So there's a mixed bag of premises that really all 9 justices have in terms of what rule of law means. And and maybe that's one of the criticisms against the current Supreme Court, or maybe a future Supreme Court as well, is there isn't really any sort of urgency, at least from the justices' minds, to clarify the jurisprudential, the philosophical principles that animate their decisions, and you see that in the sort of way that the Roberts Court is described. The Roberts Court is described as an incrementalist court, in the sense that they'll take the smallest step possible in a certain direction without then explaining the repercussions of that decision or the consequences for other things. And maybe that's a practical approach, maybe that's a pragmatic approach, but many times what it does is it injects these mixed premises or unexplained, or it sort of prevents courts or lower court judges from trying to figure out exactly what the Supreme Court meant when they said X, Y, Z, and some of that is the way that judging occurs, and Justice Gorsuch goes into that. I mean, his way of this is, there is no such thing as methodological, respect for the methodology used by past judges. So every judge has to make up his or her own mind in understanding and applying what the rule of law means. So he sort of switches between subjectivism and intrinsicism to some extent when he's talking about sort of methodological independence of each judge from another judge. And then there's the other camp on the Supreme Court that says, well, okay, this is sort of like a very mechanical exercise where we have these tools, we have tools of interpretation, we have these presumptions in the law. If there is a veteran involved, then we give the benefit of doubt to the veteran. If there is an Indian tribe involved, we give the benefit of doubt to the Indian tribe, or all of these presumptions in the law, and we just sort of mechanistically apply those principles. That's what the rule of law means, and that again doesn't really grapple with what rule of law actually means, which is a core judicial function of judging. And judging isn't a simple matter of saying, okay, this statute says willfully and recklessly, but you proved negligently, therefore you're wrong. There's more to it than that. The more is the Constitution, the more is the fundamental philosophical principles that animate the decisions that the judges provide.
So, as I said, a last question, and again, looking at it both from the point of view of the majority opinion and the dissent of, now what will the consequences of the overturning of Chevron be? So as you've talked about, you think of it, it's the overturning is a good result. The reasoning is a mixed bag, but both have impacts going forward. So that, and from the dissent side, this is one of the things Kagan says in the dissent, quote, the majority's decision today will cause a massive shock to the legal system, close quote. And so that's on the dissent side. On the Roberts's majority opinion, it's we're not saying that for the past cases that have been decided based on Chevron deference, we're not saying now that all those are void, and or even that they can be challenged simply because they were based on Chevron deference. We're not using that going forward, but that I think is trying to address, is this a massive shock? No, it's not going to be a massive shock. How are you thinking about it operating in this area? What are your expectations now going forward in the next years?
So I think, Justice Kagan is trying to get at, I think, a legitimate concern, is how I would put it, in terms of, what does it mean for the majority to say that the statute, the Administrative Procedure Act, requires the court to not defer to the interpretations of the federal official. So she's getting at this sort of this dichotomy that has developed over the decades between the stare decisis effect given to statutory interpretation as compared to constitutional interpretation. And I think the Chief Justice was very sort of practical in pegging the majority decision on the statute, because statutory decisions are have a greater stare decisis effect than the court's constitutional decisions, and that's the dichotomy. Is courts view statutory interpretations of previous courts as as stronger as having stronger precedential value, because Congress can always come in and amend the statute and thereby overrule the interpretation that the court has offered previously. But if the court decides decides a case based on constitutional grounds, then the only way for we the people to really amend or overrule that interpretation is to amend the Constitution. So we as courts take it upon ourselves to give less respect or less precedential value to our constitutional decisions for that reason. So there's this dichotomy between statutory stare decisis and constitutional stare decisis, and I think you see that concern come out in Justice Kagan's opinion when she says what she quoted, which is, what does this mean in the future? And maybe that's why the chief, I understand why he would peg it as a statutory decision, not a constitutional, because then that is set in stone to a greater extent than if he had said, this is a non-deference is a constitutional principle. So he did sort of like a smart thing when he did that, because that pretty much addresses Justice Kagan's concern. But again, there is controversy and debate about the nature of precedential effect given to previous decisions of the court. I mean, even sort of stepping back from one step and not thinking about statutory versus constitutional, I think Justice Gorsuch talks about, well, actually, that's part of judging. That's a core judicial function. We have the ability to figure out which precedents of the court have the force and effect that is to be given more precedential effect than others, and we can figure that all of that out in the future, but because that's the core function of judging. So I think Gorsuch tries to address Justice Kagan's concern. Okay, how is this going to play out in the future? You just peg this on the statute instead of the Constitution, but that will be something that will need to be fleshed out. Certainly speaking, in the future, I think this idea of applying the Loper-Bright rule retroactively to previous previous decisions, and or applying it prospectively only is a legitimate concern for many judges. How is that going to be applied? And this isn't the only time that this has happened. There have been cases where, let's say the court said you have the right to counsel in criminal proceedings. And a second case needs to go to the court saying, well, okay, you introduced a new principle. Are you going to apply that to all of the cases that were pending, or are you going to only apply it prospectively? And the court then has to decide whether it has prospective applicability or retroactive applicability. So that next case is going to come up no matter what, because to the extent that Loper-Bright is a new principle, not just an application of the Marbury principle, then the court will have to decide that question.
And so part of the dissent is painting this as, or I think at least trying to activate in some people's minds, or maybe that even you could just say the media takes it like this, whether they were trying to activate that it's going to be chaos now. Is the I mean, in part of what you're saying, and that has happened before, and that cases are brought, and that you have a gradual playing out of this. Is that the expectation that you see, or do you see any potential for like real legal chaos?
I do not see a potential for legal chaos, because yeah, that's just how gradually a court decides things case by case, and that is the fundamental nature of the judicial power. Congress can come and make generally applicable laws. They can come in and say, okay, here's the new rule that's applied to everybody, but that sort of law applies prospectively only. What a judge does or what a court does is not make the law but find the law, and Gorsuch talks about that in his concurrence. And that finding of the law is necessarily case by case, is necessarily gradual, and is necessarily designed to not shock the system in a way that Congress really can shock the system. The political branches can shock the system by creating some massive piece of legislation. I mean, think of Obamacare, think of all sorts of benefits plans that are just created overnight. So the political branches, yes, are in a position to provide that massive shock to the system, but courts simply are not designed to do that. So that concern about shock to the system coming from the dissent is really overblown, or it's really misplacing or placing the blame on courts when it should be placed on Congress, and it should be placed on Congress's sort of use of muscular legislative powers that really the Constitution does not grant Congress. Um, and that sort of goes back to the discussion of, well, yeah, will we see more cases about um, did Congress really have this power to regulate commerce, or did Congress really have this power to create this massive regulatory scheme, or what have you? We'll see more of those cases, but again, it will be gradual case by case as opposed to this massive shock that is contemplating.
Okay, thank you. So yeah, as I said, that's the last major issue I wanted to talk about. So as we close here, anything from the decision or what you think about its aftermath that you think we didn't touch on that might be important to bring up in closing?
So I think the one thing that comes to mind is, I was looking at the reactions from legal scholars right after the Loper Bright decision came out. It was interesting to see sort of the law professors being extremely disillusioned and critical of the Loper Bright decision, and that is an interesting phenomenon because I think the legal academia is. I mean, I don't want to sort of like make a political judgment as to where they lean, but really, I mean, this idea is about oh, the world has turned upside down. That rhetoric is really coming from the academics. It's not coming from litigators. It's not coming from people who have actually litigated these cases and seen what the thumb on the scale really means for the individual. So that was really interesting to see as maybe a cultural phenomenon of the divide between academia and practitioners. And then, maybe I'll just say that and leave it at that.
Okay, thank you, Eddie, for joining us today. So let me just close out here. If you enjoyed those watching today, if you enjoyed the podcast, please subscribe to our channel on YouTube. You can click the notification bell. Also, you'll get notified when we have either go live or put up new recordings. If you're watching the recording, please like it or comment or share it. That helps us reach new viewers. Then do similar things if you're on Facebook. And if you have questions or comments about today's episode or suggestions for future episodes, please send us an email. It's at newideal@aynrand.org. We read all the emails. We reply to many, maybe not all of them, but definitely if you've got some comments, please send them our way. So thanks again, Addie, for appearing today, and we'll be here again next week.